Our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property, okay? Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey everybody, welcome to the show. Today we're talking about land use and entitlement issues. I'm Andy Fowler and I'm here with Sean St. Clair. If you're new to the show, make sure to follow and like our channels. You can find us on YouTube, Facebook, and you can find us on X. On each of those platforms, we are at the handle @NREM Podcast. That's @NREM Podcast. Also, you can go to Spotify, Apple Podcast, or any other platform that hosts audio podcasts. You can download a version of our podcast. Go there. Leave us a review. We'd appreciate it. And with that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So the legal update today is really not so much of a legal discussion or update, but I did want to highlight some, potential changes in real estate lending as proposed by the current administration. Basically, the proposal by the current federal administration is to eliminate the borrower's obligation to provide or pay for, not so much provide, but pay for title insurance for lenders on federally insured residential loans. So what does that mean? So right now, the way that lending operates is that when a lender is going to make a loan on a property, they negotiate with the borrower and they basically say, hey, look, we need to make sure that our deed of trust or mortgage, depending on what state you're in, is going to be insured in, first position or second position. And if any lien, claim, encumbrance, individual, or anything else comes up out there that's going to threaten our position on this property, we're going to have insurance to protect us. And borrower, you're going to pay for that product. So you're going to provide that policy of insurance to us and you're going to pay for it. Now, when a borrower or buyer goes to purchase a home, the custom is that the seller provides the borrower/buyer with a policy of title insurance, basically doing the same thing that a lender's policy of title insurance does, but this is an owner's policy of title insurance, which basically protects the borrower's ownership in the property and ensures their position and their right, title, and interest in the property. And the seller pays for that. And that is, a fairly decent size, premium. And it's just part of the escrow closing costs that a seller has to pay. Now, when the borrower or the buyer is obtaining a loan to purchase the property from a seller and the seller's paying the primary owner's policy of title insurance, normally the lender's policy is just kind of an add-on and it really doesn't cost anything. Most title companies on residential properties throw it in for like $100. And that's the amount that a borrower/buyer would pay. So, it's like $100 because, the title companies kind of think, well, most claims are going to be covered by the primary policy anyway, and we're doing all of the work to insure the primary policy. It's really not that much more to insure the lender's policy, and therefore, it's a much smaller premium that the buyer/borrower is going to have to pay to the lender. It's a very small amount. Now, that same situation doesn't hold true with lenders who are providing, say, refinancing of the property, because you don't have an original owner's policy. And so those policies tend to be more expensive because they are going to be the primary policy. It's not just an add-on to an already existing or policy to be issued. It's going to be the primary policy. And so for refinancing, that's more expensive. And so, yes, in that case, borrower/buyer, well, it wouldn't even be buyers because they own it. So borrowers in that case would, come out of pocket a decent amount, a few $1,000s normally, to cover the lender's refinance. Thing is, right now in this climate, I don't know that there's tons of refinancing happening because most people's interest rates already are lower than what they can go and refinance at. So I really don't think there's really much happening as far as refinance. So I'm not sure that it's going to have a big impact on the refinance market. It may save a buyer of, $100 here or there as far as the purchase goes. So I'm not, frankly sure what this proposal accomplishes right now. Maybe in the future, when refinancing picks back up, it's going to save some borrowers a decent amount. For right now, it's not really much. And I don't see lenders foregoing title insurance. I don't see them saying, "Oh, okay, well, since the borrower is not going to pay for it, we're not going to obtain it." I think the lenders would just pay for it themselves and make it up somewhere else, with, whether that's, certain, loan costs or interest rates or whatever. They're probably going to make it up. And I don't see them going without title insurance, because to me, that's a very bad idea. And, when you start seeing these defaults happening and the lenders go to foreclose, that's normally when they see the title issue, and then they realize, oh, we have a real mess on our hands. We can't even foreclose. And because, we forgot to get, the title company failed to get a signature, or, failed to properly record or timely record, whatever the case may be, or there's, these other claims that were out there that were missed. But that's normally when it happens, and you're going to kind of leave the lenders holding the bag if they don't have a title insurance policy to fall back on. So I think they're still going to obtain it. It's just who's going to pay for it. And ultimately, I think the lender's going to end up, paying for it, but then, figuring out a way to recoup it somewhere else. So that's kind of the proposal out there. It could change the real estate landscape a little bit for buyers and borrowers. But I just wanted to, have a discussion on that. Really not technically a legal topic, but just more of an explanation of what initially the proposal is and what it would look like going forward.
All right. Thank you, Sean. With that, let's talk about a few updates and announcements. As always, every Tuesday at 2:00 p.m., we have the Creative Finance Collective. That's 2:00 p.m. Arizona time. So if you're in a different time zone, different jurisdiction, make sure to adjust your times accordingly. But we hold it at 2 p.m. so that folks in different states to the east of us can participate at a reasonable time. But what is the Creative Finance Collective? That is a collection of lawyers, professionals in the space of creative finance to get together and discuss all things creative finance, to discuss what it looks like to do this in other jurisdictions, what are investors running into in other states, how can we make each other's forms better. But what we're really here to do is make ourselves available for an entire hour to answer questions that you, the listener, might have. So if you have questions about creative finance, if you've wondered, maybe this is something I want to get into, what are the pitfalls? What do I need to have on my radar to know how to handle this kind of transaction? This is the time to ask those questions. We've got participants from a variety of different states: Arizona, Texas, Ohio at times, California, Alabama, Georgia, Florida. We've had them from all over the place. So this is an opportunity for you to engage with lawyers for free and discuss all things creative finance. So make sure to join us every Tuesday. You can watch it on YouTube, Facebook, or X, formerly known as Twitter. Again, make sure to join us, the @InRem podcast, and it's the Collective at 2 p.m. Arizona time. Also, so today we're talking about land use, zoning, entitlements. If you have questions for us or our guests, we'll get to the questions in the final 15 minutes of the episode. Don't wait till the final 15 minutes to place those questions. You can put them in the comments right now. We're monitoring the chat, and we can get to those if you have them. It's an important topic. It's a valuable topic and a complex topic. But if you're going to be involved in real estate investing, you are going to run into land use, entitlement, zoning issues. It's just a matter of time. In fact, you've run into it and haven't even known that you've run into it if you own real estate at all. So make sure to post those questions. All right, so let's get into our topic today. We are talking about land use and entitlements, zoning. And with us to discuss that topic is attorney Adam Baugh. Adam, thanks so much for joining us.
My pleasure, guys. I'm delighted to be here. Looking forward to it.
Yeah. So tell our listeners a little bit about you. Where are you licensed to practice law, your law firm, and how you got into doing what you do?
Absolutely. Guys, I'm thrilled to be with you today. Look, I had no business being a zoning attorney. It didn't even mean anything when I applied to law school. I came to Arizona State because I thought I wanted to be an immigration attorney. I spent a year volunteering at a detention center. And by the end of it, I realized I do not want to be an immigration attorney. Fortunately, I got an internship with the mayor of Phoenix. And when I was in his office, I'd see these guys come in and suit and tie and sort of charm their way across the 9 different council offices. And then as you'd go to city council at 1 p.m. that day, their cases would get approved. And I didn't know what they did, but whatever it was, I just knew I needed to be like those guys. And so found out that was called a zoning attorney. And that wasn't something that they particularly taught in law school. But what I saw at the end of the day was they had a gift of building great relationships and leveraging those relationships to help get their clients' projects approved. And I just knew that I might not have been the smartest kid in the class, but I did do door-to-door sales for pest control for 2 years. So I knew how to talk to strangers and make them like me in a short matter of time. And in a lot of ways, when you have to make a pitch for someone's zoning project, you've got to convince a bunch of angry neighbors, a bunch of Karens on the HOA board, and elected officials who are very affected by the number of opposition emails and phone calls they get. And so convincing somebody to say, let's say 4 out of the 7 council members to say yes to zoning case is all like selling shoes at Nordstrom or pest control on someone's doorstep. And I think in a weird way, I learned a lot in law school that I've forgotten, but I've never forgotten the skills of being a salesperson. And seeing how that translated with these zoning attorneys in the mayor's office sort of opened my eyes to a practice of law that I think works really well for what I do. But at the end of the day, what I've come to know is it touches everybody, no matter where they are, where they work, where they live, where they shop, or the deals that they put together, or the businesses that they build. Zoning affects everybody and touches all of us, even if they don't quite know it.
So Adam, tell us a little bit about your law firm. Is it exclusively focused on land use, zoning, entitlements, or do you address real estate issues more broadly?
Yeah. In Arizona, zoning and land use is a very boutique practice. And frankly, I'm not really sure that a lot of other states have the same type of emphasis of this land use law here. Our firm is Withy Morse Baugh. We're probably the largest land use law firm in the state, but we only do specifically land use and zoning issues. We clearly have some real estate folks on board. They'll handle your purchase and sales transaction, your title review, and all those kind of complementary components. But really, people are hiring us because they need to get their projects approved at City Hall. They need to get the votes at the legislative dais, which is your city council members, or they need their projects to get through the queue faster. In fact, most people will pay us for the expediency and the efficiency of sort of shepherding their plans through City Hall than just having the architect drop them in the queue and then wait for the response to come back. And so inevitably, if you have a new entitlement that you need, a general plan amendment or a rezone, you'll hire somebody like us. If you've got an interpretation issue you need to work through with the planning director or the zoning administrator, you hire us. If you have an issue with the water line extension that you don't think you should pay for, but the city wants you to put in, you hire us. If you really just need an opportunity to connect with the council member because you have a great project, but you want to see if there's a pathway to success before you actually commit hard dollars, you come to us. And at the end of the day, I sort of just tell people, I'm your friend at City Hall. What you need, I can accomplish.
So Adam, this is a podcast for real estate investors. So a lot of the folks that are watching are either aspiring or experienced real estate investors, and they've either run into the need to deal with zoning, or they're going to run into the need for it. But when should a buyer of real estate, or maybe even more accurate to say, when should an owner of real estate, when should land use and zoning be on their radar?
It should be on the radar before they do anything else. I hope I'm one of their first calls, but if not, it should be, I assume they have a buy checklist. And somewhere on that buy checklist should be proper due diligence. Look, we represent sophisticated developers, people that are building huge master plan communities, big industrial projects, hotels, commercial shop centers, residential neighborhoods, etc. But I also deal with a lot of scrappy investors who, what they're really good at is seeing an opportunity and figuring out how can I convert that opportunity into an income or an enterprise or new appreciated value. What I see often with those scrappy investors, though, is overlooking some of the most basic things on the due diligence schedule. So I assume that they have a great lender and they're
Looks like we just lost Adam.
Oh, there he goes.
There he is. Can you hear us all right, Adam?
Gentlemen, you can still hear me?
Yeah,
Yeah.
now we got you. Can you hear us okay? We'll give Adam another second to get
Guys?
There we go.
there you are.
Yeah, there we go.
We can hear you now. Can you hear us?
Good. Yeah, I can hear you just fine. So
Yeah.
at the end of the day, these investors build a team of contractors, of title people, of lenders, inspectors, hard money folks. You should have a zoning attorney on your team, because at the end of the day, you need to know not what's apparent on the face of the property. Everyone can pull it up and go, oh, it's zone C2. That means I can build my commercial business. That would be the most basic of things you need to do. But the property due diligence would hire somebody like me who goes, okay, it's zone C2, but are there stipulations on that approval that will impact what you want to do? Is there limitations regarding access points that while it looks like C2, you've got a median cut that's restricted by the driveway across the street. So you can't actually put your driveway where you want to be, renders your property useless. Are there grading and drainage issues that come into play that you need to negotiate with the city that make it difficult to execute on your plan? Is there a neighbor next door who is friends with the council member who could oppose your project? Is there an interpretation error that prevents you from achieving the vision you want to have? And just simply looking at the C2 zoning, and where I see a lot of people make mistakes, it's looking at the county assessor's map and going, oh, it says C2 on there, therefore it's allowed. The truth is they need to make sure that they check all the boxes, including the ones that they don't yet know. And that's what a zoning attorney does, is we are sort of their quarterback and help them find a pathway to success and avoid all the different landmines that they don't yet know, but will certainly prevent them from moving forward on their project.
So Adam, you're talking about the different, opportunities maybe for use of the property, but then different restrictions. And, one of the struggles that I even personally have, or a lot of my clients have, is the idea of like, I own this property. What gives the city the right to tell me that I can't do it, use it in this manner? I can't build this structure on my property. So just in general terms, as a property owner, what are their land use rights?
Sure. Every city has a zoning ordinance and it has a zoning map. And so your property has a zoning category assigned to it. And so you would just compare, if the zoning map shows you're zoned R2 for residential duplex, then you'd go to the zoning ordinance and look up what is R2 allowed. And that's probably the most basic thing. It allows one home up to, or 4 homes per acre or 12 homes per acre, depending on whatever category you have. And then it has a box of development standards, heights, setbacks, lot coverage, landscape requirements, etc. That's your sort of your developable box. that's what you would see in the zoning ordinance. But a lot of times my clients will hire me to re-entitle property. As we re-entitle the property, it inflates the value of the asset, right? They create the value themselves. That's what a smart investor does. But sometimes they'll buy someone else's entitlement case. And if they don't go down to City Hall, pull the zoning file, pull the approval letter, pull the conditions of approval, and see that, well, yeah, it's zone R2, but it turns out there was a neighbor next door. The neighbor protested the case all to the end. And so the city council, as part of its final action, put a height limitation. So even though the R2 zoning ordinance might allow up to 32 feet of height with a parapet or something like that, the actual zoning approval says 24 feet. And all of a sudden, your client who wanted to build a 2-story home can't execute on a 2-story home, even though it looks like the zoning underneath it allows it. So the zoning ordinance is the regulatory framework. The zoning approval might tighten that up a little bit. And that's sort of the box that they have to look at on how they want to execute their long-term plan.
So when you talk about entitlements, I have a rough idea of what that means, but our listeners may or may not.
Sure.
So when you use the term entitlements, kind of what are you talking about or referring to?
Entitlements are the rights that come with your property. Maybe the entitlements to build a project, to have the entitlement to do a certain type of density, the entitlement that comes with the list of uses. If you're zone commercial, depending on which city, you might have 120 different uses that could be allowed on that property. Those are your property entitlements. And you, as a landowner, and obviously Arizona is a private property rights state, and I assume a lot of your listeners, if they're smart investors, are probably developing in pro-business development states as well. So these private property rights are so inherent. I mean, they're codified in the Constitution and the laws and case rulings in the Supreme Court in Arizona, or in the state of, United States of America, in Arizona, and even in our state statutes. And these private property rights are so critical that we guard them and protect them. So your ability to invest in a project foundationally has a right to come with it, and you should be able to execute on that right. That's the entitlements.
So now let's say that hypothetically, an investor goes and they find just a great piece of property right on a corner. They're like, oh, I'm looking around. There's not enough roofs in this area. I think that this would be a great multifamily development.
Sure.
But they go and they maybe hire you and pull the zoning, and you're like, multifamily isn't allowed right now on this. It's zoned some other thing. What are their options at that point?
Sure. I think a lot of investors do a lot of DIY stuff, and I can understand why. Sometimes the cost force them to do that, but I've often see it's a big mistake for folks to DIY their own entitlement projects. And a good example of your corner is if there's a vacant corner left over, there's a reason why it hasn't been developed and everything else around it has. Those might be considered infill parcels. So you sort of need to find out what don't you know that prevents you from being successful in this project. But if it's already zoned multifamily, you would just go and build it per the development regulations that are in that corresponding zoning district. Chances are it's not. There's a reason why it's vacant. And so you come to somebody like me and say, listen, I've got this idea. I want to do multifamily. I don't know if I'm going to be doing 324 units or 286 units. But the difference between those units and the acreage I have, it may put me in an R4 category, which is higher density, or may put me in an R2 category, which is more of a medium density. What are the chances that I can get the city council to agree to the higher density or the medium density? And what I help people do is evaluate what's the process to go through? What's the likelihood of success? And is it even worth embarking on? I've been doing this long enough, and I've seen enough projects. I can kind of get a sense if there's a pathway forward to rezoning land. At the end of the day, this is a decision made by 7 council members, or maybe 5 council members, depending whose district it is. It's a legislative decision, which means they just get to call and make up their own decision right then. You need to convince them. And if I'm going to go and spend $80,000 and 6 months of my time, hire consultants and engineers to draw up plans and architects, I better be pretty confident that I'm going to get those votes approved at the end of the day. And while there's no guarantee, our job as zoning attorneys is to I think remove the unpredictability of this process and provide more certainty that the outcome at the end of the day, maybe 6-8 months down the road, is foreseeable where we launch right now. And so what I like to do is go meet with the council members one-on-one before I file anything. Go see the mayor, go see the plan director, go see the city manager, go visit with the other council members, and be able to put together a sales pitch, a story, right? I'm just a storyteller. It's the same storytelling I sold when I was selling pest control door to door, or my business partner who was selling shoes at Nordstrom's. Every property has a story. And so as we go and make this story, this pitch, I want to hear from the council members, what issues might they foresee? What are the problems that I should anticipate? And if I can address those problems, would they have any issues with my case? No one's going to commit to you. Yes, I'm a vote yes today. But at least to sort of open their mind to, I could get there if you consider or address these following items. And when I can come back to a client and say, hey, good news. I visited with staff. I've met with the council members. I've knocked the doors of some of the neighbors. I've even done a neighbor meeting, all during your initial due diligence period. And I feel confident that in these 60 days that you have your due diligence, I've been able to check a lot of boxes and get a lot of good intel. I think we can rezone this to that high density category. Or I come back and say, high density would be pretty rough, but I do think they would agree at something less dense, maybe more of a medium density. And then that developer, that investor can kind of weigh that information and go, I appreciate the input. I'm going to go forward. Or he'll say, you know what, that was money well spent, but it was too many boogeymen. I'm out. But regardless of the decision that gets made, we want to remove the unpredictability of the process in their due diligence phase so they can have the confidence to spend their money and take this through the 8-month entitlement process. Because if they can succeed there, their value of their asset will tremendously increase once the council votes yes.
So let's just talk about, let's say they want to move forward. You've come back and you're great news. I think we can get this done, but it's not done, right? Nobody's going to 100% commit until you go through the process.
Right.
And so let's say you go back and at this point in let's just say at this point, there's maybe some verbal communications, maybe I'm an LOI out there or something. And now you're like, good news. This is good. What are the options for a buyer in that case? Meaning, should they go under contract, close it, and then go to you and say, hey, walk us through the process here and get this rezoned? Or should they enter into a contract with some contingencies or maybe an option to purchase or something where they can hire you and have you walk it through without actually closing on the real estate transaction? What do you guys normally recommend as far as that goes?
Great question. And I can always tell the level of sophistication of a buyer based on the contingencies in their contract. And a sophisticated developer, buyer, investor is going to have a condition that puts closing contingent upon the zoning approval. And not just the zoning approval, but like 30 days after the zoning approval to avoid a potential referendum. Where I see a lot of reckless investors, as opposed to like sophisticated developers, is when they treat the acquisition of the property like a house. 30-day inspection period, closing, thereafter. And those are the folks that get in trouble. And then they call me and they go, dude, I really need you to bail me out of this situation. I didn't realize, I found out that I can't put a curb cut here, or there's a non-vehicular access easement, or the neighbor next door actually has a height cap easement on the property. And so the best thing to do, your buyers, your investors are going to negotiate some type of a due diligence period, inspection period, whatever. If you're going to run an 8-month zoning case, you really should do your zoning due diligence at the same time you're doing your property due diligence. So while you're reviewing your title, your ALTA, your survey, your easements, you should be doing your zoning due diligence, pulling the zoning history, meeting with the department staffs, understanding your proposal and seeing if they can get behind it. If you can double stack those two, you've gotten a leg up on your timing, because it's going to take you 8 months to zone the case. But if you just did two processes at the exact same time, you've created a greater efficiency And you may have learned something in that first 30 or 60 days of that due diligence period that tells you, boy, I better back out of this case. I just learned, X, Y, or Z. And that is so important to find out in the early phase. You should then, if you like what you're hearing in the due diligence phase, then we create a roadmap that tells you pre-app, formal submittal, neighborhood meeting, public notice, planning commission hearing, staff rounds, city council, and we kind of create this like guideline for the next 8 months. But boy, I don't even want to talk about the 8 month period if I can't really flush out the landmines in the first 30 to 60 days of due diligence. And then have a contingency that simply says you'll close escrow upon approval of the zoning entitlements or approval of the site plan or approval of the plat or a letter of confirmation from the planning department that your use is allowed. I mean, everybody should have a contingency on zoning before they move forward with the project.
Now let's say you did that. You put that contingency in place. Logistically, though, you as the buyer now have an equitable interest in the property or contract interest in the property, but you're not the fee title owner of the property. It's still the seller, right?
Right.
But that buyer is the one that's rezoning it. They're the ones presumably hiring you. So how does the city view that? Do you need like a,
owner authorization?
Yeah, from the seller, a power of attorney. What do you need so that the city's like, oh yeah, I'll work with you, buyer, even though you're not on title?
Yeah, cities, it's a great question. Obviously, whenever you're negotiating your contract with your seller, you want to make sure that you have a provision in there that requires them to cooperate in your zoning effort, to sign whatever authorizations may be needed to make formal submittals, to provide support or documents or evidence. But when you file a formal application with the city, which would come after your due diligence period, you don't need the owner authorization to do the due diligence and to pull the files and to meet with staff. But the moment you're going to file something, a variance application, a use permit, a rezoning, a general plan amendment, a plat, whatever, you're going to need an owner authorization. And there's typically a form that the cities have, or we write a little letter that we ask the seller to sign. So critical that in your negotiation of your purchase agreement, that you provide a provision there where the owner has to participate or cooperate in providing those approvals, those owner authorizations, so you can make those formal application submittals. As long as you have that, the city doesn't care who you are as an applicant because they know they have that authorization from the owner in place.
Now, Adam, I want to back up just a little step, and maybe you've addressed this, but I just wanted to clarify. So we're talking a lot for understandable reasons about due diligence here. But when I hear due diligence, it means a couple things. So it obviously means that contractual period that the parties have agreed that the buyer is going to conduct due diligence within a prescribed period of time. But much of that is negotiated and built out based on, if we're dealing with a sophisticated investor, due diligence that was conducted prior to the purchase contract, just in the initial stages. Now, I would imagine that in a perfect world, you would love to be involved in the earliest stages to see whether this is even something realistic about what we're doing. What kind of due diligence do you like to and encourage in that stage to decide whether it's even worth going down the road of engaging in the purchase contract itself?
Yeah. Let me give you a simple example. And this happened. A guy comes to me and goes, hey, there's this shopping center. It's mostly office. It's kind of vacant. I want to re-tenant it. And I have a lot of these medical users that want to go in these empty spaces. It's zoned for office. These are medical offices. Any issues that you should be aware of? On its face, you would go, yeah, it seems like it makes good sense. Empty buildings, there's office. These are office buildings. Why can't I put a dentist or a chiropractor or a eye person there? What they don't know is that the city's parking ratio is different for a general office like an accountant or a law firm than it is for a medical office. So a one parking space per 250 square feet works just fine for the accountant. But a medical office, it's one space per 150 square feet. And so this guy's whole business plan and execution of it is to be able to put in several medical practices in this empty building. He's not going to be able to do it unless he has enough parking on the 1 per 150 ratio, not the 1 per 250. And imagine buying that asset, and his whole pro forma is based on the rates that a orthodontist, a dentist, and a pediatrician can pay. Now his whole deal just blows up because he can't execute it that way. I could have spotted that in the due diligence period if he came to me early. That's the perfect example where it looks like the zoning works, but beyond its face, there's those boogeymen. Someone came to me recently and he goes, "There's this property. It's zoned RO, means residential office. Basically, it's an office use in a residential area that has some very narrow limitations. He wants to do a daycare." I said, "Dude, here's the problem. Daycares are commercial uses. You can't do a daycare in a residential office property." He goes, "But you know what? This is the right site. It's got a great area. I can put a yard." And I go, let me think. What can I do so that I don't count this as a daycare? I look at the zoning code. I go, a school is allowed in the residential office. Can we make you a school? Because, well, I said, "Tell me about your programs. What time do your kids arrive? Your instructors, are they certified? Are they teachers? Do you have a curriculum? What's your teaching look like?" And then I go to the zoning ordinance and look up the definition of a school. And as I read the definition of a school, I can see that it involves curriculum and teaching. And I go, "Boy, I don't think you're a daycare. Let's call you a school and let's make you more operate like a school. And now I can fit your school into this RO property, whereas I couldn't fit your daycare into this RO property." Those are the kind of things that you want to hire me to do on the due diligence side early. Because if the guy had brought the RO property and didn't find somebody like me, he would have gone down to City Hall. The City Hall would have said, "Sorry, we don't allow daycares here." And he's now relisting that property and losing money on it.
So sticking with that hypothetical, let's say your client goes and sets everything up, does the curriculum, calls it a school, looks like a school, operates like a school, but a neighbor complains and says, "These parents, they're coming at all hours, dropping off their kids and whatever. It's not a school, it's a daycare." Right. And the city, code inspectors come in, they're like, "Oh no, you're calling it a school, but it's a daycare." But your position is, and your clients, you can justify that it's a school. Do you become involved in those types of disputes, and kind of what happens in that case if, somebody's falsely accused of using their property in the wrong manner and you have to defend, code violations or things like that?
Yeah, great question. And when you already have a problem and you're calling me, you have a big problem. like it's a big ball of yarn, or a big Rubik's Cube. You totally screwed up this thing. I could never solve a Rubik's Cube when I was a kid. So don't bring me a Rubik's Cube. Let me solve your problem before you have that drama. Because in that circumstance and situation, what I would have done is gone to the city during their due diligence period, met the zoning administrator who has the ability to interpret the code. They're authorized to make these interpretations. And I would show them the evidence, the curriculum, the schedule, the teacher certifications, and the printouts of that, and say, "Look, my client is such and such. They're looking to operate in this location over here. It's zoned RO. They run a school. The school is for kids between this age and this age. This is their curriculum. This is their teacher. This is their hours of operation. Here's their functions. I would like to request a letter of interpretation from you that this use can be classified as a school." I get a written letter back from the city, and I'm doing all that during this kind of due diligence period. So when they close escrow, I've got a interpretation that's as good as the actual ordinance itself. So when the neighbor does complain or somebody else, I can go, "I got this letter here." Now imagine imagine me trying to get that letter after the problems occur. Do you think the city's going to give me that letter? Probably not.
Right.
And so trying to identify those landmines in the due diligence phase before drama exists, I'm far more effective. But I call those letters like letters to mom when you're at summer camp, right? If I can get a letter from mom, from the planning director, the zone administrator, before I have trouble, she's going to write me a letter back to, "Son, I love you. I miss you. And you'll never need to mow the lawn again." And that's the kind of letter I need to get from the city. And when I get that letter in the beginning, it's good. If I write mom and say, "Mom, I ran over the neighbor's dog and I used my BB gun and I broke his window," she's not going to send me that letter. That's very kind and compassionate. So having me involved in the beginning can prevent a lot of problems later on.
So back to the same hypothetical. Let's say you go to the city and you present all of this evidence and you say it is a school and here's everything we've done. It fits into the zoning. I just want to, confirm before they start operating, obtain that letter of interpretation. And the zoning administrator looks at it and says, I don't agree. But you think you're right and they're wrong. Is there any recourse at that point?
Yeah. Well, look, my business is relationships. That's the only reason why somebody hires me. It's because who I know and the relationships I have. So when they come to me and I go have that conversation with whoever it is at the city, it starts with a relationship of trust. And that administrator, the person authorized to make interpretations, has years of working together with me. They know I'm a straight shooter. They know that there's integrity behind what I'm saying, and I'm not going to pull something. So coming back will likely give them the feedback that I'm expecting to hear. But let's say that they disagree with me. Sometimes the best advice I can tell a client is to just move forward on a different property. If I think there's merits to it, yeah, we can appeal a decision to a board of adjustment, a 7-member panel who sit as volunteers. But the board of adjustment members and the makeup, it's like the guy who's your insurance person and your realtor and the sign guy. And they're not professionals in zoning land use. So they're just likely going to defer to staff. And you can appeal that then to Superior Court. But at that point, your odds are low and we're just wasting money and time when you could just move on to your next investment. So if I can identify a pathway to success in the beginning, that's the best approach than to fight and fight and fight. Spend your money with a coin flip of a result. Something that comes to my mind is a time an investor bought this property and he goes, hey, I got this at a foreclosure auction. And it's a multi-unit property, let's say like a triplex. And I wanted to go to the city to get an electrical permit for something. And it turns out there's this red dot on the city system for my property. Red dot means like an illegal lot split or unpermitted work. Dude, I bought this for the performer that showed me having 3 units, but it turns out that this unpermitted work needs to be demoed and brought back to compliance with the code. And I'm only going to have 2 units now. What am I going to do? And so someone like that would come in and I'd be able to identify it in the beginning process and go, here's what we're going to do. We're going to apply for a variance to reduce the setback. So that structure, while it's unpermitted, can stay where it is. And we'll go get the city, we'll negotiate them, we'll put a stay on any holdings, on any proceedings. So that way we can at least go through this entitlement process. Let's go get you the variance approved so we can keep the structure where it is. Once we get the variance approved, then we need to go through and permit this unpermitted structure. So let's go work with the inspector, the officials, the plan reviewers, and come up with a game plan where they can come out and do an inspection, visit, look at the property, and then you can create what we call an as-built set of plan drawings. And then we'll go back to the city, we'll get them to permit the as-built drawings. And at the end of the day, now you have a valid triplex. You can get the electrical permit to start this whole thing off in the beginning. So I've done this process many, many times. I give you endless examples, but my point is it all comes back to the same thing. You really need to find your landmines in your due diligence phase. And our sophisticated developer clients know this early, and those aren't the ones that I'm sort of speaking to in this audience. It's sort of the creative investors, the people who see the opportunity and can see the end vision, but really don't know all the steps in between. And those are the ones that I see most often finding problems that need me to come and remedy it. And it's always way more expensive for me to unwind or undo that Rubik's Cube than it is for me to be engaged on the front side and lead them to a path of success rather than undo kind of the drama that they create. And if they trust someone enough to investigate that early, not only will they avoid problems, they're probably going to lead into a path much faster. And as you guys know, time equals money, and it probably will be cheaper than it is to fix a problem and spend the money to fix the problem.
Now, part of the zoning process is to publish notices of meetings, have the opportunity for, feedback from the neighbors or other interested parties within the community. And what if you live in a neighborhood and you find out about a project that's going on? You're like, oh, that's just terrible. Like, I don't want that here at all.
Yeah.
Number one, what are your rights? And number two, is that ever something that you get involved in where like neighbors represent you or hire you to represent them to try to shut down a project?
Listen, I only represent the dark side, the big bad developer.
Okay, there you go.
I don't want to represent neighbors.
Right.
No,
Yeah.
I mean the reality is, and all joking aside, neighbors are a key component of all zoning efforts, right?
Mhm.
You do have to post a sign on your property. You do have to send letters to the adjacent owner, sometimes within 300 feet, sometimes within a mile. There's not a scenario where you're going to avoid the neighbors, but it doesn't. And so don't dig a hole and stick your head in the ground. I actually know that because the neighbors are going to be part of the process all the way to the end. It's so much better to just engage with them right away from the beginning. And I found that when I work with neighbors before I file, I always earn their trust quicker. And when you earn their trust, neighbors react emotionally, but it's rarely, if ever, factually based. And you can't go to them and say, you don't know what you're talking about. You don't got the facts. You have to go be empathetic. I understand your private value is probably the most important thing. I can totally appreciate why you might be concerned about this project. Would you be willing to be a little open-minded about what I'm going to share? And if I have that conversation before I file, I'm always able to convince them. It might take some time, but I'm always able to convince them. It's when I file something, I'm 4 months into it, and then I send them a letter that says, hey, come to the hearing in 2 weeks. They're going to go, wait, what? You're building this big industrial project next to me? You've been working on it for 5 months, and now I'm just hearing about it 2 weeks before the city council vote? And so our path to success and how we help clients get through there is to say, let's go confront all these issues head on. Let's go meet with our neighbors. Let's go meet with the HOA. Let's go meet with the Karens. Make them like us. Make them want to be part of our team. Let's have their input. Let's let them feel like they're part of creating this plan. And then also at the same time say, look, I appreciate your feedback, but on that item, I just can't do. If they feel heard, valued, and listened, then for the most part, they'll get on board. And at some time after 5 or 6 meetings, they'll just fatigue out, which is my plan. And then they won't come to city council. It's jokingly stated, but truly and genuinely sincere when I say neighbors are important to the process. And I'd rather engage them right from the beginning than have to deal with the drama of them at the end. It removes so much of the unpredictability process if I know where they stand when I first start my case.
So obviously doing what you do is very relationship driven. And your firm has established these relationships with different municipalities, here in Arizona. So does your firm work throughout the state, or are you limited to, say, Maricopa County, Pinal County, or even certain cities within, those counties that for which you work?
Yeah, we have a statewide practice. But I'll be honest. If someone comes to me and says, look, I got this project I want to do in St. John's, I go, look, I'm not your guy. I don't have relationships out in St. John's. Or, if you came to me and said, I had this really awesome project in Paradise Valley, I'd say, I'm not your guy, but my business partner is, and he's done a ton of projects over there. And our firm, there's 16 of us. We make it our mission and our intentional effort to create great relationships in any jurisdiction across the state. So whether I'm in Lake Havasu City or Tombstone, Page, Arizona, to Tucson or Sierra Vista, everywhere in between, we've created strategic relationships through the years of zoning cases, and never being, I think the integrity of what we do is so paramount that even though 5 or 6 years can go by, people remember me. They go, Adam was a straight shooter. He did what he said. He delivered a great project. He stood for the developer in a great way. We want to work with him. And it's whether it's me, my partner Jason, or any other people that work with us, we leverage those relationships across the state to get you across the line.
So Adam, you mentioned before, you referred to the rezoning process, and I know this could change depending on really what kind of zoning process we're talking here, but you estimated about 8 months. Let's talk about just some of the formal nuts and bolts of getting through rezoning.
Yeah.
I assume it starts with just a basic application. Is that right?
Yeah, I think the first thing you want to look at is the general plan. I'm assuming your clients and your buyers or your investors are looking to change the zoning to build something. And the cities always look at a couple of things. One, the general plan. Every city has sort of a map, which is a blueprint for how they expect future development to occur. And if it's something shown as red, that might mean they expect commercial on this property, or yellow, or different shades of yellow, which might mean different types of densities. But whenever I'm bringing a case to the city, they're always judging the potential of my case based on the general plan map underneath it. And if the general plan map doesn't match what I'm proposing to do, then I'm gonna have to amend the general plan and rezone the land. And I think without getting into the specifics of it, I'll just say that's an important criteria, because if I need to amend the general plan, I need to have a very compelling justification for it. To file an application with the city on the rezone is basically telling a story about why the current zoning doesn't work and why this property hasn't succeeded in a meaningful use because of its current zoning. Once we create the storytelling, then we do a pre-app submittal with staff. The pre-app is reviewed internally and then they give us some feedback. I never file a pre-app until I've met with council members beforehand. I really want to know what I'm going to get myself into. After the pre-app, then we make a formal submittal, which includes applications and forms and fees and drawings and engineers and consultants. After the application submittal, there's a couple of rounds of reviews back and forth with staff comments. We revise and resubmit, more staff comments, revise and resubmit. At some point during that process, we'll do neighbor meetings. We'll send letters out to folks who live nearby. We'll invite them to come hear about a project. And at some point, staff will say, you know what, you've now satisfied all our comments. I think we're ready to take this to a hearing. And they'll schedule us for a planning commission hearing and then the city council hearing. And we'll have to post a sign on the property. We'll have to send letters out again, inviting people to come to these hearings. And then there's a vote. And the vote will be a recommendation made by the planning commission and then a final decision made by the city council. That process, depending on where you're at, can be 5 months in like Maricopa County, or it can be painfully years long if you're in Sedona. And typically we'd say it's about 6 to 8 months.
Right. Adam, we have a question from somebody in the audience. Mayu, if you'd go ahead and post that question for us. All right. What is a good strategy to get a city to approve an Airbnb when there are restrictions?
Oh, should have expected that question. Airbnb is such a trendy topic these days. I have a couple of them myself. Short-term rentals. Under state law, cities can only act with the authority that they're given by the state statutes. State law has been, I think, very protective of short-term rentals. Thankfully, we have good legislators who understand the value of free enterprise and that type of use. And so cities and counties can only operate within the powers that the state statute gives them. So you should look at ARS 9 or ARS 11 with regard to specific short-term rentals, and then cities can only act within that power outline in there. So I have a property in Gila County, for example. They just adopted a zoning regulation without really any good feedback from the stakeholders. And that was implemented in December. It becomes effective at the end of May. And as a zoning attorney, I'm literally advocating for myself for the first time ever, as opposed to representing somebody, on changing the zoning code to be more mindful of a better legislative environment for short-term rentals. If you're in a city where that already exists, then the city cannot prohibit short-term rentals, but they can prescribe the conditions in which they can operate. So if you're asking, how do you get a city to permit it? You need to just follow the rules that they've laid out under that application process. It's not discretionary. Either you comply with those things and they have to issue you the license. And if you don't comply with those things, then you don't have a right to operate in that area. So go look at the zoning regulations, find a way to comply, and then they can't stop you from operating there, assuming you maintain compliance.
What are examples of some restrictions that cities or counties can put on short-term rentals that would comply with the Arizona law that allows for them and doesn't allow any municipality to prohibit them, but allows them to restrict? So what are some things that they're doing to try to make it overly difficult to operate in those municipalities?
Sure thing. I guess the county statute might be a little bit different than the state statute, although they're probably very, very similar. So I'll just kind of give you for example on the county. Under the county statute, in ARS 11-276, it allows the counties to regulate things like noise and nuisance and parking, etc. But it also says to the extent you regulate this on short-term rental properties, you have to equally regulate it on single-family properties. And I think that's where some jurisdictions get into trouble, is they're creating punitive or regulatory environment around short-term rentals and ignoring that if they do it here, they have to apply it equally uniformly over here. And that's an issue I'm actively working on right now. But you'll see them regulate things like parking, occupancy type, background check on guests. I've seen them implement things like fire emergency plans, pest control, noise ordinance, or designating a specific point of person to respond to in the situation of emergency or complaints. And unless you have like a legal background, I think you would just assume that whatever these cities or counties adopt is lawful. And there's probably somewhere around 1,000 different short-term rental operators across Gila County, which includes areas like Pine, Strawberry, Payson, Globe, etc. And none of them complained to the county when it got adopted. Maybe a couple of them, right? But none of them complained about the legality of it. And it wasn't until I realized, my goodness, you've adopted this ordinance that's going to completely impact my property rights and my ability to run a business, when I got involved and realized there's some things in this county ordinance that just simply are not legal. And thankfully, I think we found willing folks at the county attorney's office and the elected officials, the county supervisors, who also start to recognize that they just trusted their staff without really vetting the legality of it. And now we're in the middle of sort of rewriting that ordinance together instead of sort of being one side only.
So if I understand you correctly, and this is interesting, I never, I knew about that the cities could put in restrictions, but I never knew that they had to put in basically identical restrictions for just regular homes as well. But let's say that they require background checks on short-term rentals. Does that mean that any rental property, whether it's even long-term rental, that they have to put that same, restriction on, that, they have to establish background checks, or how does that operate?
And that comment I made about being uniform in its application, I'm only making that comment as it relates to the county statute on short-term rentals.
Okay.
I don't know if the city, because the state statute is different for cities than it is for counties.
Okay.
It very well could be the same. I've just only have dived into the county one because it's a real life issue for me personally.
Right. Yeah.
But your question about long-term rentals and those background checks, not the same, because short-term rentals are defined in a different way than long-term rentals, which is more of the Landlord-Tenant Act. Okay. And whatever state statute regulatory regime exists for that is what would be applicable there on Landlord-Tenant Act, as opposed to like short-term rental ordinance.
Right. Okay. But what if they have like a noise ordinance on short-term rentals? Do they have to have a corresponding noise ordinance or restrictions on regular homes as well?
That's my reading and understanding of the state statute.
Interesting.
Yeah. I mean, and frankly, you'd want that. In my mind, if I'm going to enforce something against the Airbnb that's renting on a weekend, I really want a well-defined noise ordinance that says noise can't exceed 55 decibels at the residential property line after 10 p.m. because the specificity of it creates better enforcement of it, which creates the ability to for a court to uphold the penalty or the violation, right? And right now, language that says you can't create a nuisance after 10. Well, what is a nuisance? Well, I hope it's well defined. Because if not, then you've written an ordinance that's not really well enforceable and will succeed when you're trying to enforce it. I just think as short-term rental operators, which is sort of the trendy investment opportunity these days, it's important for hosts to be the best version of themselves. And I think them being great operators is much better in them having success than try to fight City Hall or the county to bend the way that you need to be because you aren't the best operator. Now, if you are the best operator, then we need to make sure the county and states operate legally within the confines of the law.
Well, Adam,
that's
thank you.
That's my opinion.
Yeah.
Sorry about that.
No, thank you so much for that info. Great conversation. We really appreciate it. Tell our listeners how they can find and connect with you.
Well, thanks for that opportunity. So my law firm's called Withy Morris Baugh, and I'm Adam Baugh. And you can find us online at wmbattorneys.com. But actually, my passion is we have a little podcast ourselves. It's called Dirt to Development. And you can find that on any of the podcast sources, Stitcher, iTunes, Spotify, etc. But Dirt to Development is a great podcast that sort of tells the behind the scenes of all the projects that you live, shop, and work at today, the politics that went involved to that, and to creating that, the neighbors who were just goofy, sometimes the crazy clients you have, and all the negotiation that goes behind it. I think we don't realize how zoning touches every aspect of our lives, and that Dirt to Development is sort of the storytelling behind the projects that you live and shop at or work at daily.
Awesome. Adam Baugh, Dirt to Development. We'll put the link in the description of this video here on YouTube. Adam, thanks so much. Let's do this again.
My pleasure, guys. Anytime.
All right. Have a good one. With that, everybody, that is our show. Make sure to join us 2 p.m. today for The Collective, and we'll see you next week.
Have a good day, everyone.